I shall begin. I have a bunch of questions. I'm going to ask you to keep your answers tight. Mr. Hartley, did the union justify to you why it was pursuing political goals unrelated to wages and working conditions, which I think you listed, BDS, Medicare for All, Green New Deal, No Kings, et cetera? Did they ever justify that?
No, not particularly, but you can find these on the National United Electrical Workers website. The Stanford Graduate Workers Union website also puts information on forthcoming protests, for example, regarding the situation in the Holy Land, but not particularly when it came to actually.
I always ask people to think on the other side. What if a union was requiring people to be on the opposite side of those issues? Would the other graduate students feel that unfair? And I think this is the time for that. Mr. Vernuccio, you talk about the tension that Section 7 of NLRB prevented employers from taking actions against harassing, abusive speech. You also mentioned this as well, Mr. Beck. Where should the line be drawn between speech protected by NLRB and the harassment prohibited under Title VII of the Civil Rights Act?
Thank you, Mr. Chairman. Workers deserve to be protected, and their employers deserve the ability to make sure they are protected from vile, harassing, and discriminatory language. The Trump administration, in their General Motors case before the National Labor Relations Board, established what's known as the right line test. This said, as long as the General Counsel of the NLRB does not establish that there is Section 7 animus, or the employer is simply going after the employee because they're unionization, because they're trying to unionize, that those employers should have the ability to protect decorum and respect in the workplace and discipline employees that are violating Title VII of their coworkers.
Yeah, I agree with that. I mean, the coarseness of that exchange, of the quotes I think that you gave, Mr. Beck, frankly, should not, a fellow worker should not be subjected to. I think the Trump administration got it right there. Mr. Arnold, I'm told that the striking workers that you worked with had voted down 2 tentative agreements between IAM and Boeing, one of which IAM called a landmark contract. Now, we heard in our last hearing about the role of arbitration as a potential solution to a first contract. But as I understand, arbitration could take workers out of the process by removing the need to ratify a contract. Put differently, if the leadership came up with a contract, arbitration said, yep, this is it, then the members could not reject it. As you mentioned, they've already rejected 2 things that have been offered. What would happen if the IAM workers lost that ability to ratify a contract?
Thank you for your question, Senator. It is my understanding that in our Constitution, our members get to vote on the contract, period.
If you go to arbitration, my understanding is that if you have arbitration and it's an agreed upon, then that becomes the contract, at which point the workers would not have the ability to reject.
If that's the case, then that would be removing the democracy from the workplace, which is the whole point of a union, giving the worker a say.
Sounds good. Yeah, well, thank you for that answer. Mr. Beck, under its non-acquiescence doctrine, NLRB does not consider circuit court precedent when issuing its decisions. And the NLRB argues that it ignores precedent in order to preserve the national uniformity of federal labor laws, but then violates that uniformity by oscillating back and forth between policies based upon which party controls the board. And it's my thesis that this every 4-year oscillation we've had over the last decade has really been bad for unions, bad for business, bad for the worker, bad for our prosperity. Now, what do you think? I mean, am I overstating this, or do you feel like this kind of whipsawing is negative and that we should somehow balance it out?
I think that you're onto something there, Chairman Cassidy, both with the non-acquiescence and with what we sometimes refer to as the policy pendulum at the NLRB. With the non-acquiescence to circuit court rulings, the NLRB has not created uniformity. What results is a patchwork where we have the Third Circuit says one thing and the Fourth says a different, the Fifth says a different. What I think the solution to we can't change the fact that different circuit courts will occasionally come to different conclusions, but at least we could provide certainty to the employers within those circuits by insisting that the NLRB follow the law of the circuit in where the employer is located. In terms of the policy oscillation, this whipsaws everybody, unions, employees, and employers. And there are some classic examples from recent years. The one that occurs most obviously to me is how elections are conducted. And the Obama NLRB introduced what some called quickie elections, and others of us called ambush elections. And then the first Trump administration board went back to sort of the more standard way to run elections on a more historical timetable. And then we had the Biden board come back and change the election rule again. So this kind of policy oscillation leaves everyone wondering, my gosh, how can I plan and how do I really know how to conduct my labor relations? Because the NLRB may issue a different ruling or a different rule a year from now or 2 years from now. They've done the same thing in a way that affects the entire American workplace, not just those that are unionized, with the way the board has handled facially neutral workplace policies over the last 2 or 3 administrations. One,
I'm going to ask you to wrap that up. Hang that.
I'll just say that there's been oscillation about employment policies as well.
Sounds good.